Welcome to the Deep Dive. We take complex sources, unpack the essential knowledge, and basically give you a shortcut to being well-informed.
Yep, and today our mission is really digging into the rules around patent application filing fees in the U.S. We're focusing specifically on MPP Section 607.
Exactly. And this is part of our larger series where we're exploring the Manual of Patent Examining Procedure, the MPP, section by section.
The goal is to make it, accessible. A clear guide for patent practitioners, students, anyone curious about U.S. patent law.
Our sources today are straight from the horse's mouth, excerpts from the MPP itself. We're looking at Chapter 600, which covers the parts and content of an application.
And then really zeroing in on Section 607, the part about filing fees. We've also got some related bits from other MPP chapters that touch on these fee issues.
Right. We want to get you up to speed on these foundational fee requirements quickly without it feeling overwhelming.
And just a quick heads up on terminology if you're newer to this. MPP is the manual we mentioned, the examiner's rulebook. USC is the U.S. code, the actual law, like 35 USC 41.
Which sets the stage for these fees.
Exactly. And CFR is the Code of Federal Regulations, the detailed rules that implement the laws.
Yeah, okay, let's break it down. MPEP 607, filing fees. Where do these requirements even come from, and what are the absolute basics you have to pay?
Well, like we hinted, the authority comes from the law 35 U.S.C. Section 41, plus fee-setting power given under the America Invents Act, the AIA, as it's been amended.
So it's all laid out in the statutes and regulations.
Pretty much. And what you have to pay right away, well, it depends. It really varies based on the type of application you're filing.
Ah, okay, so it's not just one flat fee for everything.
Yeah.
What are the main categories we're talking about?
The big ones are non-provisional applications. That's your typical utility patent application under 35 U.S.C. 111A. Then there are provisional applications.
Sound like a placeholder.
Sort of, yeah. This establishes a filing date. Then you've got international applications entering the U.S. national stage, and also reissue applications, which are for fixing mistakes in patents that have already been granted.
Got it. Let's focus on the most common one then, the standard non-provisional application under 111A. What are the mandatory fees just to get your foot in the door?
For those, there are three core fees you generally have to pay. There's a basic filing fee, a search fee, and an examination fee.
Basic, search, and exam. Those are the big three.
Those are your starting point. But, and this is a really important but, other fees can definitely apply on top of those.
Okay, here's where it starts to get a bit more complicated maybe, or at least potentially more expensive. Beyond the basics, what else might you owe? Let's talk application size.
Right, the application size fee. This one kicks in if your specification, that's the written description, and your drawings together go over 100 pages.
Over 100 pages. And then what happens?
Once you cross that 100-page mark, you get hit with an additional fee for each 50-page block, or even just part of a 50-page block over that initial 100.
So page 101 triggers the first extra fee, page 151 triggers the next one, and so on. Even if you only have, say, 102 pages.
Exactly. That 102nd page puts you into that first 50-page increment, so the fee applies. It's definitely an incentive to be concise, or at least very aware of your page count.
But I think there's an exception here, isn't there? Something about electronic filings.
Ah, yes, a really crucial detail, especially for certain tech areas like biotech. If you file electronically and your application includes things like sequence listings, these massive text files detailing genetic sequences or similar data.
Those can be huge.
Right. If they're submitted in specific electronic formats like ASCII or XML under the relevant rules, they might be excluded from that page count calculation for the size fee.
Might be. So it depends on the format.
It seems heavily dependent on the format.
Yeah.
The MPP elsewhere clarifies that things like PDF sequence listings or paper ones don't get excluded.
So the USPTO is clearly pushing for specific machine-readable data formats. They'll give you a break on the fee if you give them data they can process easily.
That seems to be the takeaway, yes. It's a strategic push towards structured electronic data.
Okay, that makes sense. What about claims? Excess claims fees. I hear those can really add up.
They absolutely can. This is another area you need to watch closely. There are two main ways claims fees can bite. First, you pay an extra fee for each independent claim you have over 3.
Over 3 independent claims.
And then separately, you pay an extra fee for each claim in total independent over 20.
So wait, you could get charged for having too many independent claims and for having too many total claims, even if some overlap.
That's right. It's kind of a double check. One fee for exceeding the independent limit, another for exceeding the overall total limit.
Wow. And what about those multiple dependent claims, the ones that refer back to several other claims?
For those, the fee is calculated based on how many claims they actually refer back to. Interestingly, if you have an improper multiple dependent claim, it's charged like a single dependent claim for fee purposes, but you'll likely have other issues with it during examination.
And amendments. If you change your claims during the process, maybe make a dependent claim independent.
Good question. Yes, if you amend your claims later, maybe add claims, change types, you might trigger additional fees if your counts go over those thresholds of 3 independent or 20 total after the amendment. You have to track this throughout the whole back and forth with the examiner, what we call prosecution.
Okay, so size fees, claim fees.
Yeah.
Any other big ones right at filing?
Yes, the non-electronic filing fee. This applies if you file an original utility application on paper or basically any way other than the USPTO's main electronic filing system.
They really want you filing electronically.
They do. And to underscore that, since January 2024, there are even more fees if you file electronically, but not in the DOCX format they prefer. The message is clear: file electronically and use DOCX.
Okay, message received. Now, let's switch gears slightly. Practicalities. What if you send in a payment, but it's, say, not quite enough to cover everything due and you didn't specify where the money should go?
That happens, and the USPTO has a plan. They don't just apply it randomly. There's a specific predefined priority order for how they apply partial payments.
A priority order. How does that work?
It starts with the most fundamental fee, the basic filing fee. Then it goes down a list: search fee, examination fee, then things like the application size fee, and finally, it covers the excess claims fees last.
Why is knowing that order so important?
It's critical because paying that basic filing fee is often essential just to get your filing date secured and get the application officially received. If you underpay, the USPTO makes sure that basic fee gets covered first.
So they protect the filing date.
Exactly. You might get a notice later saying you still owe money for excess claims, for example. And if you don't pay that, those specific claims might get canceled. But missing the basic filing fee up front could mean you don't even get a filing date or the application gets bounced back. That hierarchy shows what the USPTO prioritizes for just getting the process started.
Makes sense. Secure the filing first, worry about the extras later. Now, refunds. MPEP 607.02 talks about this. Can you get your money back if you, say, file an application and then just change your mind?
Generally, no. Not just for changing your mind. The rules say the USPTO may refund fees if they were paid by mistake, like you accidentally paid twice, or if you paid more than was actually required.
So a genuine error or overpayment?
Right. Filing an application and then deciding later you don't want to pursue the patent isn't considered a mistake in that sense. The USPTO has already started its work, essentially.
So the service is considered rendered, in a way.
Pretty much. If you do think you're due a refund for a valid reason, like an overpayment, you usually need to request it within 2 years of the payment date. And there are specific rules depending on how you paid, like via a deposit account or credit card.
Okay, let's try to make this concrete with an example. Let's use the logic from the source material.
Sure. Imagine you file a non-provisional utility application electronically. Let's say it has 22 total claims, and 4 of those are independent claims.
Okay, 22 total, 4 independent. And let's say the specification and drawings add up to 125 pages.
125 pages.
Got it. So based on what we've covered, walk us through the fee calculation here.
All right. First, it's a non-provisional utility filed electronically. So, baseline. You owe the basic filing fee, the search fee, and the examination fee. Check, check, check.
The big 3. Okay, now the claims.
You have 4 independent claims. The basic fee covers up to 3. So 4 minus 3 equals 1 excess independent claim. That means 1 excess independent claim fee is due.
1 extra fee there. And the total claims.
You have 22 total claims. The basic fee covers up to 20. So 22 minus 20 equals 2 excess total claims. That means 2 total excess claim fees are due.
So 1 fee for the extra independent, 2 fees for the extra total claims. Now the size, 125 pages.
Right. It's over the 100-page limit. The fee applies for each 50-page increment or fraction thereof over 100. 125 pages falls into that first increment, pages 101 or 1.5 fee. So yes, an application size fee is required for those extra 25 pages constituting that first fraction of an increment.
Perfect. That example really shows how these different fees, basic claims, size can stack up. It's definitely not just a single number you pay.
Not at all. And this leads us to the why care part. Why is getting a handle on MPEP 607 so important for you?
Well, it seems pretty clear that getting these fees wrong isn't just a small paperwork issue. It can cause real problems, right? Costly mistakes, serious delays.
Absolutely. Underpaying fees, especially the essential ones, or missing deadlines to fix fee problems, which can lead to abandonment notices, can mean amendments don't get entered, or, worst case, your entire application gets abandoned.
And abandonment isn't just the end of that application. It can have other consequences, too.
It can. For instance, think about patent term adjustment, or PTA. That's extra patent life you might get if the USPTO delays processing. But if your application goes abandoned, even if you revive it later, that period of abandonment can reduce the amount of PTA you might otherwise have received.
Ouch. So messing up fees can actually shorten your potential patent term down the road.
It's a potential consequence, yes. So, MPP 607 isn't just a price list. It's really about understanding your core obligations from day one. Nailing this down helps you avoid these serious pitfalls that can delay things or even jeopardize your rights entirely.
It really lays the financial and procedural groundwork. Understanding it is key to starting the patent process smoothly.
Definitely a vital piece of the puzzle.
Okay, that wraps up our deep dive into MPP Section 607, looking at the rules for U.S. patent application filing fees.
We've covered the authority behind the fees, the basic requirements, those extra fees for application size and excess claims, how partial payments are handled, the deal with refunds.
And crucially, why mastering these details is so important for avoiding delays and protecting your application.
Hopefully, understanding these MPP 607 details gives you a solid shortcut for navigating that initial filing stage.
And we want to give a special thank you to Mike Shepard, the creative director who organized this entire MPP audio series.
Yes, thanks, Mike.
And before we go, one final thought to leave you with. We've talked about the complexities and the risks of fee errors. Looking ahead, how do you think technology or maybe changes in USPTO policy could further simplify fee calculation and payment to make life easier and less risky for applicants?
That's a good question. Automation, maybe integrated calculators within the filing system? Definitely something to think about.
Indeed. Now, the important reminder, this summary was put together using AI tools like ChatGPT and NotebookLM. It might have errors or omissions.
That's right. It's for general educational and informational purposes only. It is definitely not legal advice or a substitute for proper instruction. For the official word, always consult the official MPP, a qualified instructor, or a registered patent practitioner.
Please do. Join us next time on The Deep Dive as we continue working our way through the MPP.